You're listening to the Subrogation Support Network, a podcast from Mattison, Wickert & Layer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, audience. This is Ashton Kirsch, your host with the Subrogation Support Network podcast, brought to you by Mattison, Wickert & Layer. Today, we are going to talk about some really interesting recent developments in the last month or two, I believe, involving cargo subrogation. It is my privilege and honor to have one of my favorite people down the hallway from me, Mr. Lance Jones, attorney with MWL. Lance, how are you doing today?
I'm doing great today, Ashton. Hope you're doing well as well.
Absolutely. Lance has the pleasure, the luck, or the misfortune of being right next to my office. So when I'm always on podcasts or phone calls or just yelling at myself, he hears my voice. And whenever I have issues, I call Lance over. So Lance, thank you for being so forgiving and working so well with me.
I consider learning through osmosis. So I'm constantly listening to whatever's going on in Ashton's office, for better or for worse.
Well, one thing that you've done a great job is really expanding on, the knowledge that I've developed over the years in cargo claims. For the last decade, I've built up a pretty significant presence of cargo subrogation, representing motor carriers, insurance companies, brokers, all the above on cargo recovery claims. And Lance came in, for the audience's sake, so background, came in a couple of years ago. And since that time has really started to excel at it and now knows in many ways, much more than I know about cargo subrogation and cargo claims, given his building this expertise. Lance, you excited to talk about cargo today?
Always. It's my job.
Let's start with the recent developments. Seldomly do issues really get as high as the Supreme Court of the United States on issues that relate so directly to subrogation and recovery work. Tell me about these recent developments. What happened and where do things stand?
Sure, yeah. As you mentioned, my name is Lance Jones. I've been an attorney here at MWL for around 3 years, licensed in the state of Wisconsin, including both the Eastern and Western federal district courts. My primary practice, again, as you mentioned, is cargo subrogation. Although I have acted as outside counsel for brokers and shippers alike, helping them draft contracts and consulting them on liability exposure for various cargo issues. As you mentioned, I'm here to talk about this monumental Supreme Court decision in Montgomery v. Caribe. This unanimous Supreme Court decision really reshapes how the courts analyze negligence claims against freight brokers, and it significantly impacts personal injury litigation arising from trucking accidents. It may also, and we'll get into this later, influence future cargo damage and cargo theft cases. For right now, we'll break down what happened, what the court decided, why it matters, and what the transportation companies, brokers, shippers, insurers, and attorneys should be watching for moving forward. The case began with a serious trucking accident in Illinois. Sean Montgomery suffered severe injuries when a truck operated by Caribe Transport collided with his tractor trailer. The freight shipment had been arranged by C.H. Robinson, one of the largest freight brokers in the nation. Montgomery alleged that C.H. Robinson negligently selected Caribe, despite warning signs regarding the carrier's safety record. According to the allegation, those warning signs included conditional FMCSA safety rating, issues involving driver qualifications, hours of service compliances, maintenance deficiencies, inspections, crash history. The key legal question became whether federal law actually prevented Montgomery from bringing a state law negligence claim against an obviously negligent broker. To really understand the case, kind of the background, the history, why the Supreme Court decided to take it on, we need to discuss the Federal Aviation Administration Authorization Act, commonly called the F4A. I prefer the F4A because it rolls off the tongue and it's much easier to say than a five-sentence word here. So the statute contains a broad preemption provision. It prevents states from enforcing laws related to broker or carriers' prices, routes, services with respect to the transportation of property. Congress enacted the law largely to prevent states from re-regulating the trucking industry after federal deregulation. But there is an important exception. The statute also states that preemption provision does not restrict a state's safety regulatory authority with respect to motor vehicles. And now that's very important. The dispute in Montgomery centered on the meaning of that safety exception. Now, the federal district court in Illinois initially dismissed Montgomery's negligent hiring claim against C.H. Robinson. The court relied on existing Seventh Circuit precedent, particularly a case called Ye v. Global Trans. We don't really need to know the background history just to know that under that precedent, the negligent selection claims against a broker were generally considered preempted by the F4A and not protected by the safety exception. Now, the Seventh Circuit affirmed that ruling. At that point, a clear circuit split existed among the federal appellate courts. The Ninth Circuit had previously held that negligent selection claims involving truck accidents could survive because they fell within the safety exception. The Seventh and 11th Circuits had reached the opposite conclusion, so obviously the Supreme Court had to step in. The Supreme Court did, and they unanimously decided to reverse the lower courts. So importantly, and I think we need to stress this because this goes into what kind of arguments we can make on cargo theft or cargo-related damage cases against the broker. The court did not spend much time deciding whether broker negligent selection claims fall within the F4A's preemption clause. Instead, the court assumed, for the sake of argument, that preemption did apply. So the preemption is still there. It still exists. It wasn't struck down. But they focused on that narrow safety exception. The court concluded that Montgomery's claim was saved by the exception. According to the court, state common law negligence rules can constitute part of the state's safety regulatory authority. The court also emphasized that negligent hiring imposes a duty of reasonable care when selecting contractors whose work creates risk of physical harm. Because motor carriers perform transportation through trucks and drivers, a claim alleging negligent selection of an unsafe carrier necessarily concerns motor vehicles. So it falls within that safety exception. One of the most significant aspects of the decision involves the phrase, with respect to motor vehicles. 7th and 11th Circuits had interpreted that language narrowly. Now the Supreme Court rejected that approach. Instead, the court adopted the ordinary meaning of that phrase, including that it simply means concerning or regarding motor vehicles. That broader interpretation, it dramatically expands the reach of the safety exception. The courts also rejected arguments that brokers are somehow outside of the safety exception because they do not own the trucks or employ the drivers. The statute refers to the safety authority with respect to motor vehicles, not solely motor carriers. So that distinction really proved critical in this case.
Absolutely. Now, Lance, the one thing for the audience to understand, I mean, this is a huge deal. And some people listening obviously are going to be dealing with commercial auto, trucking, cargo claims in general. But a lot of people, maybe they handle P&C, they handle, fire losses, auto claims in general. One thing that just to keep in mind is this is so huge because there is an endemic right now in the industry of trucking companies and theft, of fraud. That's for a number of reasons. One of the reasons is that since the 1980s, there's been a lot of deregulation of the trucking industry. And in doing so, it's created the opportunity for a lot of smaller companies. And a lot of these companies are people that maybe come in from another country and they're immigrating to the United States. It has a lower barrier of entry to get in when it comes to the dollar value of actually starting a business. So you have a lot of very small trucking companies where you have a lot of room for theft. There's organized crime is all over this. I'll give you an example. We had a case a few years ago where I was involved in a bunch of people being arrested and indicted, FBI raid, because what they were doing is they were showing up. They'd hack into the boards. These are the brokerage boards. They'd find out where cargo was supposed to be picked up. They'd show up with the wrong truck and they'd steal it. There were other situations where these brokers, this has been a huge issue. The brokers really, because of prior to this ruling, they'd always just put their hands up and say, yeah, we did what we could. No, we don't have to do anything else. It's not our fault that it was stolen. But what happened is they'd use this ABC trucking company, Joe Schmo Trucking LLC, who has one truck. They're going to pick it up at the lowest possible rates. And then next thing you know, Joe Schmo would break down. Oh, no, I broke down. And they'd transload it to another subcarrier. That subcarrier would then steal the load. And then Joe Schmo, which is a real company, oh, sorry, it's not my fault. It's not me. Go against this company. And there for a while on those cases, we had a number where then all of a sudden, if it was expensive cargo, something that could be resold, they'd just steal it. If not, then you'd hear a few weeks later, oh, we found the cargo and it's at this truck stop. If you pay $5,000 for storage, you can come pick it up. And then there's a whole racket with the truck stop and all the above. So this is an incredibly sketchy industry. We're talking hundreds of millions, billions of dollars of lost cargo throughout the country. So, I mean, this is a really big deal, right, Lance? Just to lend some context to what's going on, right? And also, Lance, just by way of background, can you explain for the audience the 101 version of what is a broker? What does a broker do? How do they fit into the industry?
Sure. Yeah. So a broker, first of all, yes, great analysis on that. Yes, this is absolutely one of the most, impactful parts of the industry, a real serious issue, and really glad that the Supreme Court kind of expanded our knowledge on this and how we can proceed against brokers for, some of the negligence that actually happens. But a broker, for those in the audience that don't know or just want to kind of a refresher or a background, is essentially a provider. They're a platform, essentially. They serve as a middleman, kind of a middle manager, and they select the carrier. Now, I would say about 50% of the time, depending on who you are, if you're a shipper, you think that you're contracting with the person or the entity that's going to be carrying your cargo. As a matter of fact, most of the time, you're going to be dealing with a broker who subcontracts that to another carrier that they have some kind of contract with. So a broker essentially acts as this middleman where they say that they have, they have trucks that go to all 50 states. Well, they have other carriers that go to all these 50 states. So a broker is essentially someone that you're going to as the shipper or the owner of the cargo, and you're saying, hey, I want this moved from point A to point B. And they're going to say, sure, we can do that for you. And they don't really identify themselves as a carrier. They use very careful language in the wording of their contracts or in any kind of agreement that you enter into with them to identify themselves as a broker or as a freight forwarder. And they essentially say, yes, we're going to ensure that your cargo gets from point A to point B by hiring a third-party entity C, who is an actual cargo carrier who's actually going to be in possession of your cargo that you've probably never met, you're never going to meet, that is going to pick up your cargo and take it there, and you're never going to know the difference until it gets stolen. And then, or that cargo carrier doesn't exist and was a fraudulent third party to begin with, and then nobody has the cargo, and then the broker says, well, lift their hands up and say, well, we didn't really do anything with the cargo. We weren't holding the cargo, so you can't really hold us liable. So this is who the broker is. This is what a broker is. And really how their kind of middle management, it serves an essential interest for sure. And I work with brokers and they serve that interest well. But there are cases where, brokers do have to throw up their hands and say, we weren't responsible because we weren't the actual carrier. And shippers are oftentimes left scratching their heads because they didn't know that they weren't dealing with the person who was going to actually carry their cargo.
And it's the same with insurance coverage. On a lot of these cases, that's where it comes down to is we're getting cases that are in the hundreds of thousands, millions of dollars worth of cargo that they're insured and our insurance carrier pays out for the cargo. And next thing you know, like, oh, wow, they went to this huge broker, big company. Obviously something was done wrong. Well, you make the demand on the broker. It's like, well, we didn't carry the cargo. Like, sorry, see you not interested. Talk to this company. This is who took it. Then you send a demand to that company, XYZ Trucking. XYZ Trucking says, we never picked up that load. What are you talking about? Or they just don't respond. I don't know if it's 50-50, but a lot of times the response is either that or it's very easy to find online. You can find the DOT number, the FMCSA number, all the above, and they will just steal the identity of these companies, pick it up and steal the cargo. So it's a tough place in the industry right now. There's a lot of mistrust. And if anything, I mean, this ruling might hold some more parties accountable in some ways and so forth. But onto that a little bit more. On these cases, from the plaintiff's perspective, Lance, post-Montgomery hearing, how can this help plaintiffs when they're bringing these cargo damage cases?
So it's interesting. It's all about framing. And if you're a lawyer, you know that framing is extremely important when you're pleading these cases. What you can't do and what's still preempted now are essentially commercial losses. Anything that deals with brokers, price, route, or services, those are still going to be preempted. But if you approach this from a motor safety perspective, then you can say, well, the broker was negligent in hiring this unknown fraudulent transportation company, criminal actor who was never supposed to be on the road. Don't treat the lack of a safety record as kind of a neutral fact. Treat it as a hostile fact. It's aggressive. Treat it as, okay, wow. So the only difference between this criminal party and a bad actor that's not supposed to be on the road is that we have a paper trail as to why this person should not be on the road. The criminal, we don't have any paper trail at all, whether he should be on the road. And we know for sure that he's up to no good when he is on the road. So this is the safety exception that we're kind of pushing here. And what would be kind of the argument that we would want to make post-Montgomery, saying, hey, this is a negligent selection case. Don't say that, the broker didn't do a good job vetting. Don't say that they handed it off to someone that they really shouldn't have. Make it a motor safety exception. Make it an argument that, hey, you broker let someone on the road who was never supposed to be on the road, who was engaged in criminal acts, who has no record to tie them to, some kind of legitimate authority to allow them on the road. So this is, a negligent selection case, and you owe us for these damages just as you would if that person ended up hurting someone while they were on the road. It's the same argument. It falls through in the same vein.
Absolutely. And it comes in all different facts and circumstances, right? I mean, some of these brokers do have really stringent procedures. They do vet. Other brokers are just out there like, yeah, it's not our responsibility, at least pre-Montgomery, where you'd send it off and it's like, no, yeah, we confirmed that they had a DOT number. That's it. Now, there are vendors out there that are hired by the brokers. And I think this is going to be an industry that really expands, or at least has to be really vetted even further, where they're retained to make sure that the motor carriers that the broker's retaining are appropriately retained, right? Walk me through how that works.
Yeah, so the argument would basically go like this. The broker's mistake was not simply a failure to prevent the theft. Rather, the broker entrusted a transportation function to an unauthorized, unverified, and potentially unsafe actor who had no legitimate authority to engage in motor carrier transportation. Now, under this theory, the broker's negligence concerns more than just a commercial loss. It concerns who is permitted to operate within the motor vehicle transportation system. So plaintiffs would argue that a fraudulent carrier often lacks the very characteristics that safety regulations are designed to ensure: operating authority, insurance, safety, compliance, driver qualification controls, maintenance programs, inspection records, and verifiable transportation history. In other words, the absence of a legitimate safety record, it's not really just a paperwork problem. It means that the broker may have had no reasonable basis to conclude the transportation actor was authorized, qualified, insured, or safe. So Montgomery helps support this argument because the Supreme Court rejected the notion that the broker selection decisions are too remote from motor vehicles. The court explained that the carrier selection concerns motor vehicles because the selected carrier ultimately performs transportation using trucks and drivers. So it's not disassociated from that motor safety exception because the broker decides who's on the road. At the end of the day, they're the ones who decide who's on the road, and they give them the information they need to really collect this cargo.
So pre-decision, I mean, in a nutshell, it's basically you are really you're going to have a really hard time bringing a claim against that broker because you really can't prove negligence in that regard. You can't bring that case. But now, there are certain additional circumstances and ways that we can pursue the broker, even if we can't find, identify, or otherwise pursue that motor carrier.
Yes. And not only that, but before Montgomery, it really was, you can prove negligence. Maybe we were horribly negligent. Maybe we didn't care, but we're preempted from any claims, any state law claims for negligence. Even if he ended up, even if the driver that we selected ended up killing someone and we knew that there was a high likelihood that that would happen, we're still preempted. And, that was really the lay of the land in some jurisdictions more than others pre-Montgomery. And now, that opens the door for those kinds of bodily injury cases, first and foremost, which is huge, but also, kind of leaves a crack in the door open for these cargo damage claims, property damage claims, cargo loss, cargo theft. If you can make an argument that the safety exception is implicated and that you're the broker is sending people on the roads who are doing bad things that are causing some kind of loss to property or life or limb, then you can make the argument that, hey, there's some negligence that occurred here and it implicates motor safety because you allowed someone on the road who did something who was not supposed to be on the road and they caused an issue. And now you have to pay. Now we suffered a loss for it. And so that's really the lay of the land going forward. Now, this is an untested theory, and this is certainly something we're going to be seeing more and more of since Montgomery left the door open for that. But this is certainly the kind of argumentation we're going to be seeing moving forward.
So now flipping roles a little bit. Obviously, I know you also represent some brokers and help them make sure they're doing things right. You're representing the good brokers. These are the brokers where They want to do things right by their customers. I mean, we have a lot of brokers that come to us where they're almost wishing that they could be negligent because they want to have coverage. They want their contingent cargo coverage to come in to help their customers. But you're helping good brokers come up with good solutions to be better to their customers and the industry as a whole. What practical lessons do you have for the brokers on this? What should they be doing differently now in a post-Montgomery decision world?
Sure. So brokers for sure should be leaning more into negligence defenses, just as a precaution. Now, that preemption still exists. So what you really want to frame it as when you're going for that preemption argument as a broker, that preemption defense, is that the claim is really about fraud prevention, identity verification, cargo security, not motor vehicle safety. All of these things, yes, they may have been failures on our end, or this may have occurred in the service aspects of it, the vetting aspect, but those are all services. And services are still preempted because they don't implicate the motor vehicle safety. And therefore, it regulates that broker service rather than the safety authority. But here's the catch. You still need to be prepared as a broker to show that you were not negligent. You actually weren't negligent. And at least the brokers that I work with, that we work with, they aren't negligent. They really just want to get the cargo from point A to point B, just like any other business does. And they want to make sure that they're getting an A+ on the BBB. And the issue is you have these fraudulent carriers, you have these fraudulent entities, these criminal actors who hack systems, who engage in identity theft, who present all this information that it's almost impossible not to accept as legitimate or verified. Oftentimes it is, and it is a legitimate cargo company's or cargo carrier's information, but it's just not the actual entity. The phone number is not correct, and it's actually the criminal third party. So when you're calling him after he sends you all this information and you verify it, it's not actually the person that sent you that information, or that information isn't legit. And so as a broker, your role should be twofold. You should focus on that preemption argument. Say, we're still preempted because all the things that you're alleging are services that we provide as a broker. It has nothing to do with motor safety, and it has everything to do with vetting, security, and whether or not we were negligent in that aspect is moot because we're still preempted. But on the flip side, continue to push that we were not negligent. We did everything in our power. We are reasonable. We did the proper vetting. We used reputable security companies. We checked for the insurance information. We checked contact information, just contacting these people prior to sending out the information, asking them to verify over the phone. You have a simple phone call and say, hey, you sent us this information, that information. We just want to call and verify your number or your insurance number or your insurance policy number, just something that can easily identify them. Say, hey, what truck are you going to be picking this up in? What's the license plate? What trucks are licensed to you? Can you show me some kind of proof prior to us releasing this load to you or releasing the load information to you? Simple stuff like that can kind of really push the boundaries forward and really create this layered defense for a broker that is really going to be important moving forward in a post-Montgomery landscape.
Makes sense. And now when it comes to the personal injury side, I hear you on that. And that is something to be kept in everyone's mind, especially if they handle work comp subrogation. Because we've seen cases like that. We've seen cases where there's just not the driver of that trucking company, the small trucking company. They're not insured. We can't figure it out. And we're out of luck, right? That case, no plaintiff's attorney pursues it, shut down. For the comp side, now we have another avenue, right? So we should be thinking about that if we're handling comp subrogation cases, work comp subro, and there's just a broker. Previously, that case may not have been viable. Now there may be some viability to that. So keep that in the back of your mind. Now, kind of onto the issue that you're dealing with on the cargo landscape in mind. What issues, and you've briefly touched on this, but what issues does Montgomery raise in the cargo theft litigation beyond what you've already gone through?
Yeah, so some of the issues that it raises really have to deal with it. Importantly, I mean, in what aspect would you say that? In what way?
Sure. Yeah. I guess let's walk through an example case for everyone out there, right? I mean, what happens where let's build an exemplar. We are retained by XYZ insurance carrier who has paid out a claim for cargo damage. And we make a demand and we find out that trucking company that we send the demand to, because we look at the bill of lading, right? That's what we look at. Bill of lading is where we start. And even though we are insured, may have contracted with a broker, we do know who they brokered that load to. We send the demand. We get a response. And what does the response say? It says, hey, we weren't involved in this at all. This is the wrong company. We can prove that we didn't have a truck anywhere near this location. And we also only operate on the East Coast and this is on the West Coast. Sorry, you're out of luck. And while previous, like, man, we're in trouble. Does that change the dynamic now, right? Are we able to make a different argument today that we couldn't make, or at least we have a harder time making maybe a few months ago?
Yes, absolutely. So if there is a broker involved, so importantly, there has to be a broker on the other side of this. If it is just a case where the shipper actually contracted with well, in this case, it would be a fraudulent entity. But if they did end up working through a broker, then the next step would be, okay, so this carrier doesn't exist. It was a criminal third party. Why didn't the broker catch this? So the next step is sending a demand to the broker saying, hey, you were supposed to catch this. Now, first and foremost, before we get into the negligence arguments, I think it's important to note that most of the time, shippers do have contracts with brokers. And it's important to kind of go through those contracts, which usually contain indemnification or claims handling provisions, which allow the broker to voluntarily, contractually step into the shoes of a carrier. So now you're applying this carrier standard to brokers through a contract that you entered into with them. And it's very important as a shipper to scan these contracts, kind of look through them, have legal counsel assist you in making sure that you're not getting the raw end of the deal, because sometimes brokers will disclaim all liability. And now any argument that she had in maybe a post-Montgomery landscape has suddenly been signed away in a contract that she signed. So moving forward with an example, just like you provided, you would want to have a hold of those contract documents and make sure that you're reading it right, make sure that everything in there is legitimate, and make sure that as a shipper, you have some kind of rights and protections if your cargo ends up getting damaged or lost and the carrier is not being forthcoming or in some cases doesn't exist. It's a criminal party. And so you have at least some protections from the broker to kind of assist you in handling that claim and paying out in case that carrier is not someone that you're going to be getting any recovery from.
And even pre-Montgomery, I know that there were viable claims against brokers where we look at the contract and you can find a breach of contract claim or something else. So of course, you still, if this is a relationship and it's not just, hey, we're a household goods shipper or shipping one series of goods or one load, but this is oftentimes these are long-time relationships where the same shipper, same commercial entity works with the same broker for many, many years. So we always want to remember there's going to be another contract there. You want to get a hold of that pretty early on.
Yes, absolutely. Yeah. And that's kind of the first, actually, that's one of the first things I want to look at. Anytime where it's a broker as the plaintiff trying to recover against the carrier because they already paid out the shipper, or in cases where I'm representing the shipper and the person that they thought was the carrier was actually a broker, I want to get a hold of that, any contract that they signed, any terms and conditions right away, ASAP, because that's going to change the name of the game for the case. Am I going to be pursuing breach of contract? Am I going to be pursuing a negligence theory? Is there any other identifiable third parties that may have had a role in handling this? Sometimes this carrier that the broker brokers a load to also brokers that load. So they're also a broker and they subcontract it out. And then you're dealing with 3 or 4 different brokers down the line until you get to a carrier that you didn't actually know existed. And so it's very important to get this documentation moving forward. And especially if you're handling these claims, to really take hold of these contracts and really go through them, because they're going to have all the information you need. And if there ends up not being a contract, then you still have a viable pathway of recovery through Montgomery, although you're going to have to jump through a lot of legal hoops and you're really going to need the help of a seasoned attorney like the ones here at MWL to really assist you in handling these claims and looking through the file and crafting those legal arguments to make the case that, hey, you as a broker are liable because this guy should have never been on the road touching my cargo.
And now you already touched on this, but I think this is a very important and nuanced issue. But can you explain again or further on why cargo theft claims generally are going to be more difficult to pursue under Montgomery than a standard personal injury action?
Sure, yeah. And so I think that it's important to distinguish between whether cargo cases can be considered in the same vein as property, as personal injury cases. And the reason why is that it's much easier to make the argument that someone should not have been on the road if they hurt you. physically on the road, if you got injured on the road, and that it's a direct causation, right? If he was not on the road, I would not have been injured. Now, it's much harder to make the argument. You can make it, and I would be making it, and I probably will be making it, that someone should never have been on the road, and the property loss, there's no real distinction between that property loss and that personal injury case, because you were still injured in some capacity. It was an economic injury. You were damaged in some way. Your cargo was damaged. Your property was damaged. Would we really say that a person that was injured from someone that shouldn't have been on the road can make a claim for bodily injury, but they can't make that same claim for property damage to their vehicle after it was hit? It's almost a distinction without a difference, but it's the way in which you would have to craft the argument, making it explicitly about motor safety, motor vehicle safety, that motor safety exception under the F4A, really hammering home that, hey, this is a motor safety issue here. The transportation broker allowed this person to be on the road when he really shouldn't have. They had no record of his safety history, and they allowed him to be on the road. And because of that, we suffered this injury. Now, maybe we weren't hurt, thank goodness. But first of all, someone could have been hurt. And second of all, our cargo was now missing because you allowed this person to be on the road and transport our cargo when otherwise he would not have been on the road if you'd done your due diligence.
And I'm guessing that's why the absence of legitimate safety records is really so important to this consideration.
Absolutely, yeah. It's not a neutral fact. It's the absence of safety records is just as bad, in my opinion, and this is the argument I would run with, and why wouldn't you? It makes perfect sense that the absence of a safety record means that this person for sure should not be on the road. It's just as bad as if someone had a horrible safety record. The only safety record that I would accept as being something that someone that should be on the road is a safety record, someone that has a good history and a good record of getting loads where they need to go, not getting into any accidents, not engaging in any criminal activity, being up to date on all of their documentations and filings and authorizations. But absence of all of that documentation is really a huge red flag and is certainly a motor safety issue and something that should be heavily regulated. If you're a broker, that should be a deal breaker. If you can't find any information or the information is not coming back in a way that is sufficient, or it's fishy or it's sketchy, or the person that's contacting you about with all of this information, doesn't seem to know even the first thing about the information that he's sending over, that's a huge red flag. And that's a huge safety issue that should be addressed then and there and not after you've already let him take the cargo on the road.
So on a general level, I want to talk a bit more about cargo thefts, because that is a huge thing. We've been using it kind of in the example context, but obviously not every case in be it Montgomery or any of these other decisions involves theft. I mean, it's not always theft. So it's vetting other forms of negligence. But in these theft claims, what have you been seeing recently? What do you think are like kind of the strongest cases you're seeing, the strongest ways to argument? What are the defenses you're seeing, be it brokers or others making? Walk me through a bit more about where we stand on, the pursuit of these cargo theft cases. Because I can tell you, I've spoken to a lot of other attorneys at the different industry groups we're part of, and a lot of people just aren't pursuing these theft claims. I think it's unrecoverable. Where are you at on that? What have you been doing as you vet these cases, as you decide, hey, is there something there, something to it?
Yeah. So a lot of the times in the industry, we're seeing a lot more fraud, a lot more first, it's fraud on the part of the criminals, but then a laxness on the part of the broker as well. And obviously not most brokers, typically not even most brokers fall into this category, but a lot of the times brokers will just kind of throw up their hands and say, well, yeah, maybe that doesn't add up too much, but you could lose paperwork and, these guys are owner operators. You don't know what they're doing, or, they don't always have the same information, but it's just, he's a reliable guy and he seems to have a good record. So let's just kind of go run with it. And it turns out it's a fraudulent actor. Other times we'll see cases where the brokers will have these kinds of third-party platforms where they help shippers connect to these brokers, and criminal third parties are hacking these services, hacking these accounts, and really putting the screws in brokers by pretending to be this legitimate cargo carrier that suddenly had their information hacked. And now, the broker doesn't know what to do. They have to throw up their hands. And in these kinds of cases, yes, it's perfectly reasonable, and it would make more sense for the broker to come back with a stronger defense against negligence, because they really had no way of knowing that this was now a fraudulent entity, because they hacked the account and they got the account information and they were presenting themselves as this entity, and they wouldn't know that this was the wrong entity until and after, the incident takes place. So I'm really seeing more in the industry of that fraud aspect and then the hacking aspect. I know that there's this kind of newer kind of creeping situation, which is the AI. I know AI is really something that's been assisting the fraud a lot more, and it's making it harder to detect, because now you can just snap a picture of the truck and it matches whatever the description is to an extent to where you throw up your hands. If you're someone that's looking into this stuff, you really can't tell the difference now between what's AI and what's real. And so it's making it much harder to detect this stuff early on, and allowing this kind of theft to really fester in a way that it wasn't before. It was a problem before, and now it's just gotten to a point to where it's ubiquitous with the industry, and it's something that everyone in the industry is going to touch them or impact them in some way, shape, or form.
I was doing a training with a client not that long ago. It's a trucking company, and I was just showing them how easy it is to do these things in real time on, I think it was like a Teams meeting or a Zoom, wherever I was. I just went in and I used ChatGPT or whatever to take a truck, and I changed the MC, everything on the DOT number, everything. And I did MWL Trucking Company or something like that. I said, watch this, click go. Within 10 seconds, I had what looked absolutely like a legitimate decal on a truck. And that can be used in so many ways. I mean, the extent of fraud, it's crazy. There are apps now where I've seen where they can be voice changing apps, where you could, maybe that broker knows the motor carrier and they call up and they're using someone else's voice. There's visual overlay apps, which I've never really seen one that does it that well, but that's coming in the next few years where, hey, are you really Lance Jones on this video? Or are you Ashton pretending to be Lance? Whatever it could be, it's wild. And that's where we need to make sure that we're very careful. The hacking side, we have some cases and we're actively pursuing other companies, be it IT vendors, the broker in general for their cybersecurity protocols, pursuing different entities, pursuing those, the IT vendors on behalf of the broker after the broker's paid out a claim. You're going to see a lot of that in this industry as well. And especially if we start seeing brokers paying out a lot of these claims under broker negligence rules, then they're probably going to be asserting a right of contribution or a right of indemnification against another third party, which oftentimes can be, the service provider that's maintaining their board. Because for those who don't really know how this works, practically speaking, a lot of times, there's a board that they post their loads on. And then next thing you know, the motor carriers can access that board and pick up the load. They click select or however the board's set up, and now they are the one taking that cargo. They're responsible for be there to pick it up from the shipper. And the problem with that becomes if some bad actor gets access to that board and they're on that platform and they see either one, they can hack into XYZ's trucking company on the board and select the load, and then they come with a truck that has false decals, or two, they just see ABC's supposed to be there tomorrow. So they show up earlier in the day. And I've seen a number of those where the truck, the actual legitimate company shows up. Like, what are you talking about? You're already here. So, this is a big problem right now. Any other kind of avenues or ways that you've seen to recover on those cases?
Yeah. So there are actually a few cases where we've recovered against where shippers were getting cars shipped from one dealership to another. One dealership in Texas where the car that you purchased is on the lot there, and they're going to send it to the other dealership in Wisconsin. So that they can pick it up because they live in Milwaukee or whatever. In these cases, I've seen cases where the dealership just doesn't do their due diligence. They're saying, okay, well, the guy has the name already, and the name is pretty unique on the owner's name, the new purchaser of the vehicle, and so this has to be the guy, because how many other people could have this name? Well, it turns out in the case, at least the one that I was handling, this is a real case, there were multiple people with that very unique name in the small town that the guy lived in. And so, that's not a good excuse anyways for a car that's, an exotic car like this one was. But, those are some of the instances where, yeah, you can pursue the dealer. Yeah, the criminal third party, he took it off the lot. The broker is not going to be someone maybe that you can pursue. And the carrier is definitely not someone you can pursue because it was a criminal. But you can pursue the dealership. Another instance is the, security company, the security vendor. And this is especially important if you are a broker, or if you're a shipper with no recourse against the broker. You want to pursue someone who was responsible, who vetted this guy to allow him to accept loads. And suddenly, the security company has to come up and say, well, we did our due diligence. We are responsible for this loss. So all we did was verify this criminal third party in a negligent and reckless manner. And so those are some of the newer arguments that you're going to be seeing, especially against the dealership side of things. That's a much simpler avenue, a much easier one, but it's not often the case that there's an avenue of recovery in those cases. Most of the time, the broker or the carrier actually owns the lot in which this cargo is picked up. But there are cases where it is a third party that is involved in this cargo, cargo warehouse that just, it advertises itself as, we're a third party where any cargo can just come and sit here, and we just you can come and pick it up whenever you want, and it's going to have a distribution center for all sorts of cargo. And so you can pursue those third parties as well. I've seen recoveries against them as well, where they don't have adequate locks on their facility. They don't have cameras. They don't have people patrolling the lot, especially at night. They don't have any kind of security system to ensure that nobody gets on that lot without somebody knowing or someone being alerted. And so no kind of motion sensors, especially on the trucks. They can just get bolt cutters and cut the truck open and just take it off the lot and just back up a pickup truck and just take everything off the lot. I've seen that happen. And the only reason I've seen that happen is because sometimes those facilities don't have cameras, and it's the camera across the street for the McDonald's or something that catches the criminals in the act at this distribution facility that should have had cameras to begin with. So it's all of these entities that had something to deal with, where they had some kind of contact with the cargo, where if they had done their due diligence, if they had not been negligent, if they had done something that they should have done to begin with to prevent this cargo theft, that's a liable party. That's a party I'm looking at and saying, hey, you failed to do something here, and now we're out of pocket because of it.
Yeah, and it's important to give instructions. We're seeing more and more often that when it's being picked up at, let's say, the dealership for that vehicle, there are additional instructions that come along with it. Check driver's license, right? Don't just verify the name of the company on the truck. Check the license. Look into it. Different avenues to vet. Now, when that isn't done, that obviously strengthens. Like, I just had one of those lines not that long ago where the driver's license was supposed to be requested. They never asked for it. That strengthened our case significantly. We also get probably dozens of cases every year where the trailer's just on said lot sitting there and it's stolen at night. Because a lot of times you think of this scenario, if you're not really in the industry that much, where trucker comes up, backs up to the dock leveler levels it out, cargo's loaded, they take off. That is very common. But it's also very common to have trailers left overnight, left for days, left for weeks, right? Or loaded in that manner, at which point in time, it's sitting there wherever it's sitting, be it at the shipper's location, at the consignee's location, at some third-party broker, the warehouse, wherever it could be. Those companies can be held responsible for negligent security or any other sort of form of negligence that we can show. And that's where a lot of times these cases really do require us to put on a plaintiff's hat. We need to think like plaintiff's attorneys. That's what I always say. I trained on that just the other day at CLM Focus Conference. That's my main thing. Think like a plaintiff's attorney. Also, this is another area of law that I was just in London. I was meeting with a lot of, not brokers in your context, but insurance brokers and, a lot of these companies, MGAs, a lot of syndicates and different groups, people that do a ton of cargo work. And one thing that really they didn't grasp at the time until we discussed is the idea that this is unique. If you are an attorney handling auto subrogation claims, and that's what you've done your whole career, frankly, even product liability, you could be an amazing lawyer. If you don't deal with cargo claims, a lot of stuff's going to be missed. These cases are extremely nuanced. Obviously, we talked about these very nuanced issues when it comes to Montgomery and theft and so forth, but just the standard cargo claim, which I'm going to push back the audience. Lance joined the podcast, maybe last year at some point, and we talked Cargo 101, the Carmack Amendment. cargo claims are strict liability. Negligence isn't even relevant, right? Or it doesn't really even matter in that context. But these are tough cases. So I just encourage, that's a takeaway for the audience, as I like to give. You need to find experts in this field, right? If you have questions, Lance is the guy to call. Absolutely. One other thing I want to ask you, just about, as we talk about the cases, Montgomery, we were talking earlier today, you mentioned an Aspen case. Remind me a bit about Aspen still is in play or still remains important. What's Aspen and how does that impact post-Montgomery world?
Sure, yeah. So Aspen American Insurance Company, the Landstar Ranger, it held that cargo theft negligence election claims were preempted when they focused on verification failures rather than vehicle operation, maintenance, driver conduct, or roadway safety. So moving forward, how would a plaintiff distinguish Aspen after Montgomery? Because Aspen is still good law in that it doesn't conflict with Montgomery. By arguing that Aspen focused on dispatch and verification failures, while the newer claim focuses on negligent entrustment of transportation to an unauthorized and unsafe, there's that word again, safety, actor whose lack of authority, compliance, and qualifications creates a transportation safety risk. So, the strategy moving forward on that is to survive that preemption challenge. Again, I'm going to hammer this home, alleging that the broker selected an unauthorized transportation actor with no verifiable motor carrier authority, insurance, safety compliance history, driver qualifications, equipment controls, thereby creating a motor vehicle safety risk connected to that loss. And so if you can create that motor safety risk connected to the loss, where you will be able to with these criminals because they don't have a history, I mean, maybe they have a criminal history, but we don't know who they are, then you're really going to be setting yourself up for a stronger argument going into litigation, or in that first initial demand to an adjuster or to a broker who's either claiming preemption or is trying to create these kind of elaborate negligence defenses.
I'm sure that also has an interplay with kind of pleading strategy and what we're going to allege if we actually do file a suit and so forth, right? I mean, that's what we're focusing on.
Yes, it's very important. Again, framework is everything when it comes to pleadings after Montgomery. Really hammering home that it's a motor safety issue and not a failure in verification or some kind of negligent hiring. It really is a negligent selection and a motor vehicle safety issue, and that's going to be the name of the game moving forward, because there's going to be this desire by a lot of claims adjusters and many lawyers who don't understand the cargo industry to fall into that trap of, okay, Montgomery now says that we can pursue anything against the broker that we want and make any claim against the broker. We can say that they negligently selected him and hired him. They didn't do the right verification. They didn't take the kind of steps necessary to make sure that this was an actual cargo carrier and not a fraudulent entity. All of those arguments are going to be preempted because they focus on the service aspect of the broker. But instead, when you move forward with an argument on motor safety, you're saying, you broker, you selected this person who should have never been on the road, and you knew he should have never been on the road. And because he was on the road, we have a motor vehicle safety risk that led to this loss. That loss could be bodily injury, or it could be a cargo loss, but it's a loss all the same. And Montgomery allows us, and that says that is a safety exception, and we are allowed to pursue it.
Thanks, Lance. I mean, obviously, this is extremely informative, a big development. I mean, before we wrap up, to anything else that you want to talk about or anything else you think is important to the audience on, be it cargo claims in general, Montgomery, the decisions, what the future looks like?
Yeah, I think something to kind of hammer home your point about the kind of nuances of cargo claims. A lot of adjusters, a lot of people, maybe even in the cargo industry, don't know this, but CARMAC actually does not apply to brokers. It only applies to two parties, essentially. It applies to the motor carrier, and it applies to the shipper or the owner of the cargo. The shipper and the owner of the cargo is the only person that's allowed to make a CARMAC claim. A broker is not allowed to make a CARMAC claim unless they have an assignment of rights from the shipper. A broker does not make cargo claims. They don't have an authority without that assignment of rights, where they essentially step into the shoes of the shipper. They have contractual rights if they have a contract with the carrier. So if you're a broker and you have a contract with the carrier, you now have a right to assert a contractual claim most of the time, most of the ones that I see for indemnification, but Carmack is no longer in the picture. It's no longer a defense either. The other side, the cargo carrier can't say, well, it's been 9 months, so you can't make a cargo claim. My response to that is, I'm not even making a cargo claim. I'm making an indemnification claim under breach of contract. You have it. You have to sit, we reimburse the shipper. You have to reimburse us. And so a lot of the nuances there are very important. And I think that it highlights just how complex this field is and how important it is to have competent legal counsel who can assist you in these cases and really help hammer home the points that need to be hammered home in order for you to get a recovery and you to be made whole.
Absolutely. Lance, extremely informative. I always love to have you on this show. Obviously, I think probably in 6 months or so, we're probably going to get together again on this because I'm assuming that as things develop, things are going to come down, right? Precedent will continue to get created. Things will be interpreted. I mean, hopefully in good ways, but obviously as this relates to cargo, I'd assume we're going to see more. So we'll report back. I'll get you back on soon, okay?
Yeah, sounds great. Awesome. Thank you, Ashton. Love to be on it.
All right. Well, Lance, thank you. Audience, thanks again for joining us. This is Ashton Kirsch signing off with the Subrogation Support Network. Until next time.